Thank you. In the third block, we now come to the prohibition of the abuse of a dominant position, be it an individually or jointly dominant position, formulated in Article 102 TFEU. Let me first give you the wording. Beg your pardon, I was too fast. The system and then the wording of the provision. We have the provision itself. We have the concept of dominance, which may be very difficult to master in practical day-to-day life. We have the intention of the provision, which I will probably revert to in several different chapters when talking about it. And we have examples of abuse that I will present you whilst we go through the slides. Now, the wording is that any abuse by one or more undertakings of a dominant position is prohibited insofar as it affects the internal market or a substantial part thereof, and insofar as it affects trade between member states. So already the wording by one or more undertakings shows you that we're talking about single dominance or joint or collective dominance. Moreover, there's an interesting issue when you see that, and this is very peculiar to this provision and differentiates it against 101. It says the abuse of a dominant position within the internal market, this is the European Union, the internal market, or in a substantial part thereof. This is a different concept as compared to 101. And a substantial part thereof could mean and meant in practice in the past important infrastructure hubs. That could be things like airports or seaports, and there's respective practice on that. And then you will have, again, a non-exhaustive list of what constitutes in particular such abuse. And out of this bundle, I will later on take two examples and guide you through. So the abuse may be constituted by the direct or indirect imposition of unfair purchase or selling prices, limiting production markets to the damage and prejudice of consumers, applying dissimilar conditions to equivalent transactions, one of the probably most complex issues here, and finally, the prohibition to couple certain things. So let's assume I was the most important worldwide producer of USB sticks. At the same time, I'm also producing raincoats, two items that are not related at all with one another. And I'd say, of course, you can be my customer and purchase USB sticks, but you can only do so if at the same time and simultaneously you buy 500 raincoats. So this coupling of two products or product and services that are not related can constitute the abuse of a dominant position. First question, therefore, is what is a dominant position? And dominance is a concept that is based on an underlying specific product and geographic market. And once again, comes down to the idea of know your markets, analyze them by precedent. So product market is everything that is substitutable from customer perspective. Geographic market is ultimately being determined by, in particular, barriers to entry and freight costs. So in the elder jurisdiction of the European courts, there is one definition of what a dominant position can be. And this formulation has meanwhile even become law in Germany. Let me guide you through. It says it's ultimately, and this is what the European Court of Justice ruled in the vitamin cartels case regarding Hoffmann La Roche, it's the possibility of an economic operator to an appreciable extent and independently act of its competitors, its customers, and ultimately the consumers. So the dominant undertaking can operate independently from its competitors and from its customers. So when you see this definition, I apologize for the two typos here, you can see that the intention of the provision is twofold. It shall protect a competitor, so it has a certain horizontal direction, and at the same time it shall protect the customer. And both directions and intentions of the provision can be interwoven in the respectively cases. Now, what determines the possibility to ultimately act independently from my competitors and eventually also customers? That is in particular, but again, not exhaustively, the market share. And then again, you need to determine what is the relevant market, what is my market share. But the market share may be a dynamic element. And you would need also to look into other issues like, have there been developments recently? Are there new entrants into the market, or are such entries announced and shall happen in the near future? Do you potentially have countervailing buyer power? And then you're already deep down into economic analysis. Now, the key issue is, once you've determined the market, the question is, which market share triggers dominance? And here, you are facing a twofold issue in practical life. The first thing, and I mentioned that in the previous presentation of the first two blocks, is the markets are eventually not defined unanimously all over the world. And the second element is the market share threshold to trigger either individual or joint dominance may be different from jurisdiction to jurisdiction. So while you may eventually be deemed dominant in the EU, you're not dominant in the US. And you would have to adapt your behavior respectively. Let me first give you an idea of what the different markets can be. Now we'll give you an example from a case that is about 11 years old, but in practical life, in the chemical industry, has massive importance and implication. So in 2009, German chemistry producer BASF purchased Ciba-Geigy. And when purchasing this company, they purchased a massive portfolio of pigments, so colorants, chemicals that are used for colorants, color effects, and everything. So this transaction was notified to the US Federal Trade Commission, the US FTC, and in parallel also to the European Commission. And basically, both competition authorities cleared the transaction, but with a very different approach. The US FTC said, look, we have this market of pigments, and then you go into certain, what is this pigment class and that pigment, and the geographic scope of the market is a worldwide market. Okay, fine. So you know you have a product market per pigment class, and you have a geographic market which is worldwide. And when you have these two elements, you can calculate and measure your own market share against it. However, the European Commission in the very same case said, yes, the product market is this and that pigment or pigment class. However, the geographic scope of the market is EU-wide. It's not worldwide, it's EU-wide. And then you have a totally different market concept. And of course, you know, segmenting the geography into regions like the Americas, the EU, or EMEA, the APAC, the Asian Pacific corridor, and so on and so forth, that may lead to a totally different result in market shares. And you need to be aware of that. And the European Commission, to complete that example, has taken this approach from Ciba-Geigy and has used it ever since in chemical and pigments cases. And they're using specific criteria because they say, we're looking at sourcing criteria. Is the sourcing done regionally? Is it done globally? And all these things. So we have a clear divergence of two competition authorities. And that is something that may make things very, very difficult in practice. And I'm just providing one example. The other one is, what does constitute or trigger a dominant position? Now, to give you an example, the European Commission will look into individual dominance as of a market share of potentially 40%. So will the German Competition Authority do? Below this threshold, it's somewhat complicated. But in the US, for example, you have totally other thresholds, which are higher. And you have a safe harbor that for itself in the EU would already constitute a dominant position. So with one and the same market share and a geographically segmented market, you may be not dominant in the in the US, but dominant in the EU, and you may have to adapt respectively. And this is what makes things complicated in day-to-day life. Now, I wanted to continue by giving you an example of what collective dominance is. And here I wanted to revert, in the absence of any written EU law, I wanted to revert to German law, which has a specific presumption of collective dominance. And that presumption may be rebutted under certain circumstances. Let's go into the legal presumption, the statutory presumption of what is and constitutes collective dominance. So it is given if either 3 or fewer undertakings reaching a combined market share of 50%. So 3 suppliers, for example, have a joint market share of 50%, no matter of how this market share is kind of allocated and attributed amongst them. Or the relevant market consists of 5 or fewer undertakings which reach a combined market share of 2/3. So in this situation, you have a statutory presumption of collective dominance, except in very, very specific cases, but you have the presumption and you're up against this presumption and you have to rebut it by saying, look, this collective dominance does not apply if the undertakings demonstrate that the conditions of competition remain substantial and we have no paramount market position in relation to the remaining competitors. Something difficult. I'm not really aware of cases where it has been possible for the undertakings to rebut the presumption of collective dominance. As previously mentioned and seen on the definition of dominance, the possibility to act independently from a competitor and from the customer, as kind of reflected in the market share, you can see that, as I mentioned, the provision tries to protect competitors and customers alike. So you have a horizontal protection line and a vertical protection line, and both can be combined respectively. To give you an example, a loyalty rebate or a top slice rebate, we'll get to that in a moment. So a loyalty rebate basically means, or let's say a top slice rebate. I have a customer that sources 60% of its demand for a certain product with me. And I tell him, look, I know that 40% remain and you source them from another supplier. If you, however, switch to me and you cover the additional 40% with me, I'll give you a top slice rebate, which would apply to the 40% that you purchase on top from me, and eventually also the 60% of the other supplies. What would that activity ultimately mean? It means that you foreclose the market because there's a 40% demand of the customer that is covered by a competitor. And you basically now foreclose it and make it impossible for the competitor to supply these products or this amount of product. And secondly, it's the carrot effect. Like you want to make a rabbit run. And of course, you put the carrot in front of your customer, say, if you take off the additional 40% from me, then. And in that situation, of course, the customer will not look to the left and to the right and to possible other sources of covering its demand, because it will only consider the rebate. And when it is at a certain stage and says, okay, I only have to order an additional XYZ, and then I benefit from the total rebate, then is basically that you exclusively link this customer to you. So you have really a double situation: foreclosure of the market towards your competitor and the linking of your customer to you. Now, I want to give you 2 examples out of the category of 4 abuses that are listed in the non-exhaustive list of Article 102 TFEU. One is the direct or indirect imposition of unfair purchases, selling prices, or trading conditions. And there is, meanwhile, a massive stream of precedent in what that can eventually mean. And these are massive price increases that are not justified economically or otherwise by anything. So to give you an example, the Higher Regional Court of Frankfurt in 2010 dealt with a case where the price for a specific pharmaceutical was increased by 400%. The court found that this was completely out of range, and it looked at the price increases in the previous years that had been there, but significantly lower, like, 5, 6, whatever. And then all of a sudden you have this 400%. It says this constitutes the abuse of a dominant position. As a consequence of this case law, the German Competition Authority investigated, and I listed one case. Again, it was a raise in price for a pharmaceutical, but in that case, the German Competition Authority closed the file because it said, okay, eventually it could not prove the over proportionate price increase, and because of it was a specific situation. It was a purchaser that acquired a company that was selling OTC, over-the-counter pharmaceuticals. And the purchaser justified itself and said, look, I invested a massive purchase price and I have to kind of get my price back somehow. And therefore, I have a significant price increase. So that was a peculiar case. But in order to give you more examples, I also mentioned a very recent case from the European Commission. So on 11 February 2021, the European Commission closed a file by accepting commitments from the pharmaceutical company Aspen that it would reduce its prices across Europe for the next years for certain cancer medicines by an average of 73%. So you see, this price increase triggered the abuse of a dominant position. And it's not the only case, in fact, that has happened. And I've listed other cases, exemplary cases that you can see, where national competition authorities in Belgium, in Spain, and Italy took up this or similar other cases. Now, I'm coming to the economic kind of high-profile art of rebates, the application of dissimilar conditions to equivalent transactions. Now, what does that mean? It basically means that you have to offer every customer the same price if you are a company that is either individually or jointly dominant. So the same price basically means what happens if you offer a rebate, or what happens with other price models. Now, the same price means one thing. Let me give you an example. Let me give you the example of a company that is dominant in the production of a certain type of machine or machinery. Along comes a customer and says, this is a great machine, and you have supplied me this machine. However, unfortunately, this machine had a defect, and that caused a damage to me, and the damage was 1 million euro. And please, supplier, I want you to reimburse that. Then, if you are dominant, you cannot simply pay out on the mere belief or suspicion that there is a case on reps and warranties, because if you paid out, you'd respectively decrease the price for this customer, which then would constitute the application of dissimilar conditions to equivalent transactions. One customer benefits massively from a technical rebate, even though there's no case for reps and warranties. So this means that you really have to check whether there is a case for reps and warranties, whether the time period is there, has not expired, whether there's in fact a defect of the machine that has not been caused by the customer, and so on and so on. It also means that you cannot apply so-called loyalty rebates. Please bear in mind the image that I gave you, the image of the carrot put in front of the customer, that you make the customer run until the very end of a year, and then it places the final order and gets a retroactive rebate of 10–15%. Same the top slice rebate that I just presented you, that has been decided by the European Commission in the case ICI soda ash, so Imperial Chemical Industries. And this is the situation where you already covered a certain demand volume of the customer, and then you said, if you give me the rest, I will give you a top rebate on the rest that I supply to you, but also on the portion that I already supply you with. So the science of rebates is kind of unlimited, but it always bears down to one differentiation. Is there a retroactive rebate? That's kind of a generic overarching term the European Commission uses. Or is it a mere volume rebate that is admissible? And sometimes in practice, it can be a challenge for a company that is holding a dominant position to eventually restructure a rebate. So it is not retroactive. It has the same, or at least similar, economic implications as a volume rebate. To restructure from retroactive into volume rebate can be a tool in your toolbox of compliance. But watch out for volume rebates. So in principle, volume rebates are not considered to be the application of dissimilar conditions to equivalent transactions. There is an economic rationale behind it. One customer purchases 10 items. The other customer purchases 25. So its purchase volume is significantly higher, and he may have the benefit of a respective volume rebate. But what is the importance of such volume rebate? It needs to be economically justified. And this flows from the jurisdiction of the European courts, in the case Michelin 2. And when I say Michelin 2, you can imagine there was a case Michelin 1. So you have an undertaking that has repeatedly infringed competition law. In this very specific case, which is somewhat elder, Michelin offered certain retroactive rebates to his customers for specific new truck and bus tires and also retreated, so refurbished tires. And the commission took it up and said this is a retroactive rebate and fined the company nearly 20 million euros. And Michelin took it to the European General Court, the first instance, and this court dismissed the claim from Michelin and upheld the decision of the European Commission. And that's where the case ended, because Michelin did not take the case up to the European Court of Justice. Now, this being said, it's important to note that in that case, which I quote, even though it's somewhat elder, the European Court has taken the opportunity to define how a volume rebate can be economically justified. And I want to shortly guide you through this. And of course, the details need to be discussed on a case-by-case basis. So, here's the quote. The first important thing to say, a real volume or quantity rebate, as the court puts it, is not the abuse of a dominant position, is not applying dissimilar conditions to equivalent transactions. However, there is a proviso to that. It says, quantity rebates are therefore deemed to reflect gains in efficiency and economies of scale made by the undertaking in a dominant position. And that means, as you can see from the quote, that a volume rebate or quantity rebate is only justified if there's an economic rationale behind it. And the rationale meaning that there's a cost saving for the seller and supplier. And that by way of the volume rebate, he transmits part of these cost savings to the customer. Our customer has the benefit of participating in cost savings. Well, what does that mean? It does mean that where you operate a volume rebate in practice is not just sufficient to say, look, this is a volume rebate. That doesn't work. So the label is not sufficient. You need to have an economic rationale. You really need to prove that there's an economic reason behind it, that there are cost savings that you partly share with the customer by granting such a volume rebate. So rebates are non-admissible rebates versus volume rebate and the economic rationale behind it. And in practice, that's a very, very wide field. This would complete the third block and now lead me to the fourth block and the final block, which is merger control and gun jumping. Gun jumping describes an activity whereby two undertakings either do not notify an acquisition to competition authority, even though they are obliged to do so by law, or where they eventually have notified such transaction, concentration, but they await not the outcome decision, the clearance decision of the competition authority, but instead they start implementing it prematurely. For example, by joining distribution teams, jointly visiting customers, and these things. So I would like to go with you through what are examples of such gun jumping rules and where and precedent and where it comes from. Now, European merger control is a relatively new discipline. I mean, meanwhile, we have some 10,000 cases that have been decided upon by the European Commission. But when you consider that the agreements on the foundation of the European Union stem from 1957, it took more than 4 decades to establish a system of European merger control. And it was first established in this regulation 4064 of 1989, so 42 years after the first Roman agreements. And that is what has now become the Merger Control Regulation 139 of 2004. Now, the reason why it took so long is just a historical one. The reason that basically the introduction of a European merger control regime means that to a certain extent, the national competition authorities have to give up competence. Nobody likes to give up competence. So it was 2 judgments of the European Court of Justice in Continental Canon Europemballage, where the court indicated, well, you know, we don't have a system of European merger control, but eventually the provisions of 101 and 102 can be used for merger control, which is somewhat of a nonsense when you take it from a theoretical and structural approach. But the European Court of Justice was a pacemaker, basically saying, if you don't issue a regulation on merger control, I may, start developing jurisdiction on it, even in the absence of such regulation. And this is what put the member states together and issue a respective merger control regulation with very, very high thresholds. This is a double set of thresholds, which is very high. And only if you exceed that, then you're deemed, and you're triggered a duty to notify to the European Commission. If you're below that threshold, you go to the national competition authorities. So it's a one-stop shop principle. So it's either the Commission or the national competition authorities, even though there are exceptions to that concept. So in the merger control regulation, the new one, 139/2004, you read the concept that if you have to notify a transaction in 3 or more member states, you may alternatively, in a reasoned submission, go to the European Commission and file there. So this is an exception from the one-stop shop principle that I just mentioned. So the regulation lies out that if a concentration has a community dimension, it has to be notified to the European Commission. And community dimension, as defined in the merger control regulation, is the exceedance of these one of the sets of thresholds. There are 2 alternative turnover thresholds, and if they are exceeded, the transaction has a community dimension, has to be notified to the European Commission. And if no such notification is effected, or the participating undertakings implement the transaction without clearance, they may be subject to a fine, quite high fine, as set out in Article 14, paragraph 2 of the Merger Control Regulation. And I will revert to you with some striking recent examples that show you in which direction the fines go. And there's basically only one direction, which is up. Now, for me, the key of explaining of how it can come to a situation of gun jumping is twofold, and I want to lay that out to you. The first one is that you calculate the turnover thresholds inaccurately. And in this aspect, which I cannot go into detail here, I just want to make you aware that balance law, auditing, balance sheet law on consolidation, on turnover, on attribution of turnover is one thing. Competition law, turnover, allocation may be a totally different thing. And therefore, it is tremendously important, and it's a massive source of mistakes in international transactions, to properly calculate the turnover achieved by the relevant corporate group in the last completed business year. Let me just give you one example, which is that under IFRS rules, or even German Code of Commercial Rules, you have the possibility to deconsolidate de minimis. So let's assume you're a 7 billion turnover corporate group, and you set out the rule that you say, under balance sheet rules, I can deconsolidate and not list any kind of undertaking I control that achieved less than 5 million in the last completed business year. That may be reasonable and justified under IFRS, because the underlying idea is that auditing these companies would be eventually more expensive than, auditing when compared to the turnover they achieve. However, competition law-wise, it's a totally different thing, because let's assume that in this example, under your rule with a 7 billion turnover, you have 10 of these participations worldwide, 10 affiliates. Each one achieves a turnover of 4 million. That would make a turnover of 40 million, which is not reflected in your balance sheet. But under competition law, it may still be decisive, so as to determine, have I exceeded the threshold? Am I under the duty to notify, yes or no? Well, that is very, very important. There is a deviation between balance sheet rules on the one hand and competition law rules on the other. All I can say at this point in time is be aware of it and try to manage it when you come into this situation. Things become even more difficult when you're dealing with jurisdictions where the duty to notify is basically not depending upon the exceedance of certain turnover thresholds, but market share thresholds. And there are a number of such jurisdictions worldwide which set out market share thresholds. And here you have the duty that you have to say, okay, what is the market? What's the product market? What's the geographic size of the market? What is my market share? What may it be in future after the acquisition? So you see, again, it's the concept, know your markets. And the second possibility is the awareness of the duty to notify. So you file, but you consummate prematurely. In the examples I gave previously, already in the ongoing proceeding, you address joint customers, even though the competition authorities have not cleared the transaction. There was a case in Germany, the Mars case, related to the acquisition of pet food, where exactly this happened, the premature consummation, and cost €1 million fine. So, this being said, and having made you aware of these situations, I wanted to shed some light on precedent. The elder cases, and I think those were cases still under the regulation 4064 from 1989, were Samsung and Maersk. In Samsung, it was the first time ever a fine was issued by the European Commission for Samsung not having notified a certain transaction to the European Commission. And can you imagine, and this is of historical interest only, Samsung defended itself by saying, our Californian legal advisors have not been aware of the duty to notify, and the European union. That did not at all make any difference for the European Commission, and they set the fine. And the sole reason of setting this fine was to have a precedent case on which they could build their future decision practice on. And the next case was Maersk, as a Danish container freight company, and it back then had a very specific corporate structure, because on top of the structure there was an association rather than an entity, corporate entity like a limited or a stock corporation, whatever. And therefore, for a certain time, Maersk believed that it could reduce its turnover calculation because ultimately there was an association, eventually even a non-profit association on top, on heading its corporate group. And at some point in time, the advisors of Maersk said that, hold on, that cannot be true. And they started notifying to the European Commission. And then the European Commission set a fine of 500,000 euros against Maersk. And you can see already from the relation, 30,000 in the Samsung case is quite a symbolic fine. When you take 500,000, you know, it's more than around about 15 times the first symbolic fine. And from this platform, the following precedent has developed. So we have the case EU COM M7993 Altitze, as a French company, that repeatedly infringed the prohibition of gun jumping and was imposed a total fine, also for acting repeatedly, of 125 million euro. Imagine that size of a fine. You have, I'm afraid to quote this, a Japanese precedent, Canon Toshiba Medicals. That was a transaction which was basically effected in 2 steps. Sometimes you have these acquisitions, you know, first you acquire 10%, then the outstanding 40 or whatever. This was a 2-step transaction. And the Commission said, look, already the first step triggered control, triggered a concentration that exceeded the relevant turnover thresholds and therefore should have been notified to me, which you didn't do in the first step. And therefore the Commission set a fine of a total of 28 million. So in that case, the fine was attributed in equal portions of respectively 14 million euro to each of the participating undertakings. Then there is even jurisdiction and judgments on this area. So we have a relatively new case in Movi, where the Commission had issued a fine for gun jumping of 10 million, and where the General Court upheld the decision. And then there is little elder case, which is still interesting in the idea of what the concept of gun jumping is. So please recall the 2 elements that I mentioned on top of the page: the inaccurate calculation of turnover threshold, and second, source of mistake, the premature consummation of a transaction. So the case KPMG Denmark related to the second category, premature consummation. So it was an idea where a big auditing firm purchased from a competitor the auditing firm and arm of a separate country, and in this proceeding, which was a purely national proceeding, the question came up of whether this certain behavior constituted gun jumping or not. And since the Danish rules were very close to the European rules and rooted therefrom, the case was related to the European Court of Justice. And the court ruled that in this very case, there was no gun jumping. And the case related to the following situation. So say, for example, Ernst & Young purchased KPMG Denmark, and the organization KPMG Denmark then terminated its agreement with the mother entity KPMG. And the question was, would this termination of the relationship with the seller already constitute gun jumping? And the court had no, this would not be the case, and said, first of all, the termination of an agreement with the seller does not automatically imply the integration of this entity with the purchaser. So you always have to look, does the respective incriminated behavior lead to an integration with the purchaser? And this was not the case at present. And secondly, it is not an act that is definitive. The termination of the agreement with the mother entity KPMG is not definitive, because ultimately, if wanted, such agreement could be renewed. This would complete my overview over 4 key elements in competition law, the last section, gun jumping. So in order to conclude, I want to thank you for your attention to this presentation. Make sure that in cases of doubts, you contact your compliance officer. Do not be afraid of doing so. Install a proper compliance organization within your company. Install a hotline number. Do whatever it takes, because the risks and burden of an antitrust proceeding of whatever nature are so costly that they are for sure outweighed by any compliance organization costs that you may incur. So when weighing that against each other, the decision is very clear. And if afterwards still questions remain, contact legal counsel. Eventually, if so you may wish, that might be me. You will find my contact details at the end of the presentation. Thank you very much.